Good evening. Thank you, Grace and Jenna. Of course, I think, more qualified to speak on the reservations part of it and the constitutional aspects of that issue, given that's where my work is. And I just want to, and it raises, as I was going through the policy brief, it raises an incredibly complex set of constitutional questions that could arise in the future, and then it might be important to think through some of those issues. And I think reservations is an issue which has suffered from a distinct lack of constitutional nuance in terms of how we understand what the Constitution is doing with reservations and why it is doing the things it's doing. And I think the first level of that confusion is that the three spheres of reservation in the Constitution, be it in legislative bodies, public employment, and what is broadly known as education, but though Article 15 is not in that sense limited to education. So these three spheres, we tend to think that the purpose of reservations in all these three spheres, legislatures, education, public employment, that the function is the same. But none of the judgments really get into why do we have reservations in public employment as compared to the question of why do we have reservations in education and why do we have reservations in legislatures or in representative bodies. And once you start thinking about that question, I guess you could come up with about broadly 4 reasons as to why reservations could exist in the Constitution, and the Constituent Assembly debates speak to that justification as to why we have reservations. One is a sort of argument about historical compensation, that it is a measure to correct certain historical social wrongs, and it's in the framework of historical compensation. That's one way to think of reservations. The second way is that reservations are needed to achieve a certain representative character of our public institutions, be it higher education, primary education, or legislative bodies, that the purpose of reservations could be to achieve that representative character. It is to achieve the presence of certain categories of excluded or minority sections of our population. It is to ensure their presence. The third is a far more ambitious and often misunderstood purpose of reservation, is to achieve redistribution, that it will bring about, in that sense, there are certain set of opportunities and that there's a certain redistribution of resources, that it will achieve that sort of equitable distribution of resources, be it jobs, or that it is capable, or we think that reservations are capable of delivering that equality, right, on their own, that they're capable of bringing up a whole section of population, and in that sense it has a redistributive function, right? And the fourth, and I think the least discussed, is the symbolic purpose, and perhaps the most maintainable justification of reservations, is a symbolic function to say that by ensuring presence of certain groups and members of certain groups in certain positions, you're saying that these institutions are now open, that these spaces are now accessible, are no longer the monopoly of certain dominant sections of society, that these spaces have been opened up, right? So if we start thinking about these 4 different justifications, and then sort of superimpose the sphere in which these reservations happen, be it political representation, be it public employment, or be it education, and I think you will start to see that different justifications play a different role given which sphere you're talking about, and that nuance is very much necessary. And I think, and then the reason for getting into this sort of discussion of why reservation, why reservation in certain spheres is extremely important in constitutional discourse, given the manner in which the courts have tried to restrict who can be given reservations, when can they be given reservations, how much reservation can be given. And you can't answer all these questions, you can't answer all these constitutional questions without having that normative clarity on why we provide reservations to whom and where. And these answers will differ, and I think we need to start acknowledging that these answers will start differing depending on the group you're talking about and the sphere of reservation in which you're talking about, right? And I think the other big doctrinal challenge that exists in reservations discourse is, are reservations anti-efficiency, right? Are they anti-merit, right? Of course, Indra Sani says a great number of things about picking up from the earlier decision in N.M. Thomas, that reservations are a facet of it, that they are not an exception to equality. They should not be viewed as an exception to equality. They are in furtherance of equality, and that has very grave constitution, I mean, very significant constitutional repercussion to completely, and that was earlier the Supreme Court's position up until N.M. Thomas was that reservations were an exception to equality. They took away from equality. And starting with N.M. Thomas, they start to understand reservations as a facet of equality, as furthering equality. But yet, there is great amount of discomfort in the court's jurisprudence, right, on are they anti-efficiency and and it comes to a sharp conflict when you start talking of reservations in super specialized courses, when you start talking of reservations in certain kinds of jobs, defense forces or scientific labs or DRDO, there the language that the court starts employing is one of cost. That the nation and the society cannot be asked to pay a cost, and reservations is then again presented in that mold of having to pay a cost, right? Whereas it's, and that sits very uncomfortably with the larger discourse on reservations in Indra Sani, and that sort of and I think all of these are important questions to worry about as the claim, as the movement goes about this very detailed conversation on how to implement reservations, to be very careful to avoid the kind of traps that other kinds of reservation models have encountered along these lines in our constitutional history so far. And I think the empirical evidence one is a particularly, and I see that that's a specific recommendation, that empirical evidence. And I think reservations is one site of constitutional jurisprudence where the demand for empirical evidence is almost used as a constitutional maneuver to restrict reservations, right? In terms of saying, show us the evidence, right? Show us the evidence. And this is particularly true of Article 16, Clause 4, where the constitutional requirement is that you have to show inadequacy of representation. And I think the brief, the policy brief rightly notes that trap that 16.4 presents, and 16.1 does not present that trap. 16 clause 1 does not present that trap of saying that you have to show that there is inadequacy of representation. And nobody knows what this inadequacy is. Inadequacy where? At an all India level, at the sub-cadre level, at the cadre level, at the state level, at the district level, right? And there's no clarity on where this inadequacy and what amounts to this inadequacy. And therefore, I think it's extremely important that reservations for transgender persons be avoided, that a great attempt be made to avoid it under 16 clause 4. Right? And there is a lot of restriction coming into 16 clause 4 reservations, and 16 is only on public employment, of course. Even with the recent judgment that Justice Nariman wrote on on this concept of creamy layer, right? And introducing the concept of creamy layer as a facet of equality even for scheduled castes, right? Which is something that Indira Sahni had avoided. Again, Indira Sahni, of course, a case on just on OBCs. And I'm saying that there are certain constitutional traps that exist for reservations under 16 clause 4, and 16.1 is certainly a far more preferable route. And my sincere apologies to the non-lawyers that, I just keep assuming that you know what, when I say 16.4, 16.1, as though it's some magical act that I'm performing. But just to imagine that it's far more easier to give reservations under 16.1 and a lot easier for the state to do it under 16.1 and a lot more difficult for courts and constitutional challenges under 16.1, 16 clause 1 than it is under 16 clause 4, right? And I think this is played out particularly in the context of reservations for Muslims. This demand for empirical evidence, right? And I think you start, if you give in too much to that, it starts to operate as a way for the court and people who challenge the reservations to restrict reservations. And we need to be very careful about what is the appropriate role for empirical evidence in questions like this, right? Particularly in an issue like this, where I don't think we can ever be sure about the exact numbers, right? In terms of what is the population of transgenders in this country, I assume, given the experience of discrimination around it, we are never really going to have an accurate sense of those numbers, right? In terms of, and I think the most complex part of the policy brief is the recommendation on horizontal reservations and compartmentalized horizontal reservation, as both Jana and Grace were referring to, in terms of saying that we are far better off having this kind of horizontal compartmentalized. And if I may just say, why does that matter? Why does it matter as to whether you have horizontal compartmentalized reservation, and why can't you just put transgender persons into the OBC group and let it be? Or and I think the idea is that even within these legal groups, in that sense, they are not social groups, right? In that sense, the OBC category is a legal fiction, right? Just as the scheduled caste category is a legal fiction. It's not a group that exists in that sense. It does not exist as a social reality. The law creates it, right? The law creates that group, and within that group, there's a lot of hierarchy and inequality of opportunity, even within beneficiary groups that are identified, be it OBCs or scheduled castes and scheduled tribes, right? And therefore, to just include transgender persons within that group without a further compartmentalization would be deeply problematic, because you then subject transgender persons to the internal hierarchies of that group, of that beneficiary group. You subject, if you don't compartmentalize, right? If you don't compartmentalize within these beneficiary groups, you subject them to the hierarchy within those groups. Now, a constitutional discomfort that you run into is the decision of the Supreme Court in Chinnaya on the understanding of who are scheduled castes, right? Now, let's say you want to say, okay, I'm going to have a 3% horizontal reservation for transgender persons within the scheduled caste category. The court, when dealing with the question of the homogeneity of, or the lack of it within the scheduled caste groups, seems to think that as far as the law is concerned, that homogeneity cannot be disturbed, right? That they form a class, not in the Marxist sense, not in the Marxist sense class, right? But they form a class, they form a group. And for it to be a group, there has to be a homogeneity, and you can't start introducing further distinctions within that group, right? As far as the law is concerned, right? And of course, the limitation of this concern is that in Chinnaya, the court was dealing with the attempt by Andhra Pradesh to further subclassify on the basis of caste. It was not a further reservation for women within scheduled castes or transgenders or the idea of poverty within that. But I think that is going to be, especially within the scheduled caste category, that might be something to watch out for in terms of the court's own understanding of the homogeneity or the legal homogeneity of these groups. And I think, but just to take that point further on how these groups, that any group that you form, let's say, if you take scheduled castes and scheduled tribes as a legal group formed by the law in that sense, and we can go into why that is so, to account for how will the system of reservation account for the internal hierarchies within that group, right? Okay, you're saying, okay, if you have scheduled caste as a group, now you're saying we will have 3% reservation for transgender persons, right? But the internal hierarchy of that legal group is anyway going to be further reflected even within this compartmentalization that you seek to create, right? So it's not going to escape the internal hierarchy of the scheduled caste group is not going, you're not going to suddenly evade that hierarchy by creating a compartment for transgender persons, right? And that's something to address how for even if you say that the group that you're concerned with is scheduled caste transgender persons, the hierarchy that operates within the scheduled caste will also operate, right, within that subcategory that you're creating of scheduled caste transgender persons. And to then have a further mechanism, right, to address that disparity or inequality. And I think all the answers to internal differences or internal hierarchies within the larger beneficiary groups need not be sub-quotas, right? I don't think then you say, okay, if you're a poor transgender Dalit, then 1%, right? I don't think creating further quotas is the answer. I think the answer is to create an internal form of prioritization as to who gets to access it first and who gets to access it later, right? But I do think it's extremely important, even within this framework that you recommend of horizontal compartmentalization, to be cognizant of that hierarchies could operate even within that compartmentalization, right? And I want to end only on a larger reflection on what do we expect reservations to do, right? I think very often in our social and political discourse, we expect reservations to do a lot more work than they are capable of doing, right? And I say this as somebody who is a strong supporter of the framework of reservations that we have, but I think very often we put too much load on it and that it is incapable of delivering. It cannot deliver social transformation, right? It cannot deliver, it cannot perform that redistributive role, right? It cannot uplift an entire section of population by giving them educational opportunities and jobs. It's not going to do that. It's incapable of doing that. It's incapable of doing that because fundamentally because the pie is so small and it has to, it's apportioned 100 different ways, and it cannot deliver that kind of social transformation. But that is not to say that it does not have a role in social transformation, right? But its role has to be very clear as to what is its specific role, and it just goes back to my the comments that I started with. Why do we have reservations? It is capable of performing or being understood as performing 4 different functions, And I think we would all do well to be brutally honest with its capacity to deliver social transformation. Thank you.